Good morning.
Good morning, Your Honors. May it please the Court. My name is Joshua Klarfeld, and I represent Dexcom, Inc. in these consolidated appeals. Aspirationally, as Your Honor said, I'd like to reserve 2 minutes for rebuttal.
How many?
2.
2. Okay. Thank you.
We respectfully ask this Court to reverse the District Court's orders remanding these 3 cases to State Court. Dexcom removed all 3 cases on diversity jurisdiction grounds, which gave the District Court gave the Court subject matter jurisdiction over the cases. Nonetheless, the District Court remanded based on the forum defendant rule, an objection the plaintiffs raised for the first time more than 30 days after the removals.
That's not entirely true. It also remanded because it said that the removal was a legal nullity. You've got a better argument on the second ground, but the legal nullity is an interesting one. I don't think we've seen it, and I'd like you to direct us to some case law where removal has happened before the complaint has actually been processed.
Thank you, Your Honor.
Can I just tell you a few things before you start, too, so that you can probably, that I have on my mind?
Sure.
So that'll allow you to address, your time, and maybe we won't interrupt you quite so much. We've got something called SNAP removal that's been decided in others, but I'm going to call this super SNAP removal in terms of that it happened at the electronic filing before it was actually file stamped. So we've got that. And circumscribing all of this is the defendant forum rule and when the 30 days start to run, all of those type of things. And so in terms of, I always like to think when I look at a legal rule, if I'm going to make one, I like it to be something parties can understand, and also that we don't allow for gamesmanship on either side, that we don't take away. Obviously, plaintiffs have a right for remand. We know that that exists. Defendants have a right for removal. We know that that exists. But then the dates when it attaches and when the 30 days start to run are all a bit unclear. And in this situation, and we're in the age of electronic filing, and if we say that it has to be actually file stamped before it's filed, it must go through that process, and that's where the 30 days start to run. That creates one situation. If we, and what Judge Nelson said, if we say that you filed it too early, then when it is file stamped, are you required to file a supplemental? I'm trying to think of all of this ahead so you can answer my questions because I don't know the answers. My understanding with the defendant forum rule is that whenever it's filed, that's when the court looks at the defendant forum status. So obviously plaintiffs want to serve defendants and claim that later. Defendants want to jump and get it at the earliest. I think clearly if you filed it before there was even electronically filed, we can't let people, we can't be mind readers. But then courts get behind and they don't maybe file stamp things. So tell me all of that. So.
Okay. I think I've got all that.
Well, I know you've thought about it.
Yes.
And I know the other side has thought about it. So help us.
And I appreciate the narrowing the argument for us. So first, with respect to the question of what the district court did, Your Honor is obviously correct that it did refer to the filing as a nullity. We view that as the way that the district court extended the 30-day motion to remand rule. So to pivot on that.
Well, but I don't read it that way. I mean, I think the question is, and I think this is a question of state law in California, so maybe you can help us out here, is when is the complaint filed? There could be 2 rules. There could be a rule that it's filed when it's electronically filed, or there could be a rule that says it's filed once it's processed and file stamped. I think a state could adopt either rule, but what has California done?
So with respect to that, there is a California statute on point. The California statute is California Code of Civil Procedure 1010.6E3. And for under 1010.6E3, a document is deemed filed when it is the date, if it is clicked submitted by the party on a court date, then at any point between 12 a.m. and 11:59 p.m. on that date, if that's when it's submitted, that's when it's deemed filed. I can read the statute. It's any document.
Can you repeat that again? It was 10
Sure.
what?
It's California Code of Civil Procedure 1010.6 E3.
But do the surrounding statutory provisions affect that? So there were provisions within the same section of 1010, additional subsections to talk about if the complaint is filed, it doesn't comply with the court's rules, and it's rejected, and whether it's tolled. It would seem that all of those rules are unnecessary, tolling, if it were filed as soon as it were submitted.
So there is an additional portion of the statute, which is 1010.6A1D, which defines electronic filing, and the term electronic filing also does not include all of the processing. However, under that provision, a document is not deemed, quote, officially filed until it is stamped by the clerk. So the way we read that is if there's a rejection issue because of some noncompliance, then 1010.6A1D comes in to say, 1010.6E3 says it is deemed filed on the earlier date, but 1010.6A1D doesn't recognize it as officially filed until that defect is cured.
Now, if it were a statute of limitations problem.
I'm sorry?
If it were a statute of limitations problem and it gets rejected, would that, did they make the statute of limitations or not?
And that's exactly the point here, Your Honor. Although this is not a statute of limitations.
I realize that.
Okay, this is not a statute.
I'm not on the wrong case today. Yeah.
If there is a statute of limitations problem, the way these two code sections operate together is that the statute would not be blown. So the earlier date of submission, the date of when the party clicks submit, so when it is deemed filed, that will save the statute of limitations. And part of our argument here is that what would happen, and I appreciate that Your Honor is looking for a bright line rule, what would happen here is the very same document would be deemed filed for some purposes, statute of limitations, but not for others. So you would have the very same document that, on the one hand, the plaintiff satisfied their requirements to get that filed before the statute of limitations ran, but at the very same time, that same document would somehow not be considered filed for purposes of removal.
Well, why is that problematic? Because the statute of limitations raises separate concerns, and the idea would be not to have a plaintiff lose their cause of action because of a delay in the clerk's office in officially filing a complaint. So it seems that those cases are easily distinguishable, and that's a carve-out. It doesn't seem to create any parade of horribles that these two things are being treated differently because they are, in fact, different.
So preliminarily, the statute itself does not carve out statute of limitations. It's just by operation of the rule that works.
And the rule, wasn't the rule amended after a fairly harsh result in some California case law?
That sounds correct. And I think it was amended in part because of the advent of electronic filing, which takes us back to, even if the court wanted to look pre-statute, because the statute is based on the same analysis that courts applied, and they uniformly, in California, in federal and in state court, hold that constructive custody of the clerk is what matters. So when you look at and that's true not just for statute of limitations purposes. We cited in our brief to the Pangilian case, which is a California state court case that had nothing to do with the statute of limitations. It was a filing deadline, but it was the court held, and it's just the holding that when a document is within the constructive custody of the clerk, that's when it's considered filed.
Was that didn't that case involve a default?
That case involved
So it would be a similar situation that the party would lose their right to even appear in court if they were defaulted.
I believe it was the timing for filing an appeal, but the more we cut into this exception and that exception, at a certain point we're just carving out exceptions and just leaving behind statute of limitations. When the black letter law in California is that on the date Dexcom removed these cases, they were at a minimum deemed filed under California law, and at a maximum under the case law, they were within the constructive custody of the clerk. So either way, the complaint was not a nullity. I mean, by statute, it was not a nullity.
Well, I mean, it's an interesting question because the 6E3 says deemed filed, but then if you go to 6A1D, it's officially filed.
Correct.
I don't think we have that in the federal rules, and so I don't know. I mean, I'm not sure. It's file stamped on the date that it's officially filed.
That's correct.
So the rule you're asking us to adopt is one that no one would be able to determine just based on pulling up the record and looking at the complaint, because the complaint would be stamped on the wrong date.
That's correct, Your Honor. I don't think that it's true that it would not be able to be determined because
because you'd still see the electronic filing in the
correct
the record.
Correct. And Your Honor asked if I could point to some case law, and the truth is this is a matter of first impression. Initially, I thought it was a matter of last impression because I didn't think it was going to come up again, but in fact, it has come up. Since we filed our appeal, it came up in the Northern District of California in the case of Martinez versus Airbnb. Well,
it seems like this is going to happen more and more because there's like this race to the courthouse, and to Judge Callahan's point, we've got to, whatever the rules are, we've got to figure out the rules. But I think what's a little bit troubling is we're being asked to weigh in. If we were interpreting Federal Rule of Civil Procedure 3, okay. But we're actually being asked to determine how California treats these rules. I feel a little bit less sure about that.
And I'm sorry.
Go ahead.
That is correct. And under Bush versus cheap tickets, that's exactly the analysis, which is a Ninth Circuit case. That's exactly the analysis this court is asked to undertake. It's asked to determine, and the language in Bush is actually interesting here because Bush talks about using state law to determine commencement, and the court there said commencement in this context refers to when the action was initiated in state court. It doesn't say filed. It says initiated. And I don't think there can be a question here that it was initiated as soon as plaintiff's counsel clicked the submit button. And that happened under...
Does that mean that this should be certified to the California Supreme Court?
I don't think it needs to be certified because we're asking for an interpretation of a California statute which
there's
under...
no cases. I mean, I haven't dealt with a situation like this where there's no case. Usually we'll have some case out there, an intermediate case. There's nothing.
There is nothing. There is a reason, however, why I don't think it needs to be certified. And the reason, and why the case needs to be remanded. The question here really boils down to one of subject matter jurisdiction. And Your Honor, Judge Callahan, you asked when the clock runs. 28 U.S.C. 1447C is very clear when the clock runs. The clock runs, it's 30 days from the date the notice of removal is filed.
But the district court concluded that that notice of removal was a nullity. So if it wasn't timely, why shouldn't the clock begin to run from the date that the defendants filed a supplemental notice of removal? I mean, why should it run from a filing that has no validity? Why should the clock start then?
Well, the clock should start then initially because the statute itself, 28 U.S.C. 1447, doesn't carve out exceptions other than for subject matter jurisdiction.
The statute says after it's filed, 30 days after filing, and so that takes us back to the state law question of when is it filed. If the district court correctly determined that it wasn't filed until it was officially filed under California law, why would we start the clock under 1447 at the date of the invalid removal?
So that is similar to what happened in the Martinez versus Airbnb case in the Northern District of California. There, the court, we think, went the wrong way on it because it addressed the same issue as the same state court filing issue as in this case. However, the court there recognized that there was no subject matter jurisdiction issue. The parties agreed, the court agreed that...
Is that on appeal as well?
It's not. That one couldn't be appealed because the court remanded the case. But importantly, what differentiates that case from this one is the motion to remand was filed within 30 days in that case. And that's why that case, even though that was a snap removal case as well.
Don't you, am I misremembering? You have 30 days to remove the case too, right?
You have 30 days from the date
whatever the date of filing
Well,
is.
that was my point. If you did 30 days from the officially filed date, and we had adopted the rule that you're asking us, then we'd say, sorry, your removal was late.
We don't have 30 days.
I understand that, but you understand the complexity here where I got to admit, if I were a defendant, I would think I would have 30 days from the file stamp date on the document.
It's neither. It's 30 days from the date of service.
But
that's
right.
There's a Supreme
so
Court.
that resolves that concern.
Yeah.
So let me just.
I see that I'm.
It's service over receipt.
We're asking you questions. I'll still give you 2 minutes for rebuttal since we're gonna ask both of you a lot of questions. So that's the way it'll be. Could the plaintiffs have served you before it was file stamped?
I don't believe they could have. The plaintiffs would need a court-issued summons, and I don't believe that they have
So
that.
now, as a policy matter, whether we can consider that or not, you're asking for a safe harbor for SNAP removals.
Well,
Because you're saying we can remove it, but they can't serve us. So we get 3 days, 5 days, whatever, where we have free reign to get into federal court.
if we had notice of the filing, that would be the outcome. It's a plain reading of the statutes, and we recognize that. I don't know that I would call it a safe harbor, but I understand Your Honor's point. It is a plain reading of the statute. It is a quirk in the way the clerk's office sometimes works. Sometimes everything happens on the same day.
Sometimes they don't file things forever, and
Correct.
obviously that can be problematic.
Yes.
But defendants don't really generally change where they are. I mean, that's still going to be the same, but if they can't serve you when it's before it's electronically filed, or if they can't serve you before it's stamped, then, I always look to, I'm not an agent of either of you. We're trying to interpret the law, and that I think that might be an important point. But let's assume that, just as hypothetical, because I know this isn't what you're asking for, but let's say it was your super snap was premature and therefore a nullity. And so then you have to wait for when it's file stamped, and then then it would be timely, correct? Then they would have fallen within the 30 days from when if you have to file a new supplemental
Correct.
motion. And basically the motions to remand, we don't have jurisdiction over those. So if we decided it was a nullity, then the Ninth Circuit, my understanding is we don't have any case law on snap removals as opposed to the super snap. Then we wouldn't even get to that issue, right?
If I'm following, Your Honor, there is no Ninth Circuit case on snap removal. That's correct. There's no Ninth Circuit case. And we're not asking the court to reach that.
It's not exactly squarely before us. There's a way to decide this case without deciding that.
Quite frankly, as much as I would like the court to decide it, I don't think it would be proper for the court to decide it. I don't think the court needs to decide it, because fundamentally the question here is, did the district court have subject matter jurisdiction over the case when it was removed? If this court holds that it did, then there is no question that the 30 days runs from the 30 days on the motion to remand under 1447 runs from the date of the notice of removal.
But if it's subject matter jurisdiction, then the 30-day clock doesn't matter, because subject matter jurisdiction can be raised at any time. I thought that was how you won this case, by saying that they've waived the defect.
No, that's exactly correct, Your Honor. If this court determines that there was a subject matter jurisdiction defect, then the 30-day rule is out the window.
Then we have to affirm.
You have to affirm,
Yeah.
correct.
I
But-
appreciate the candidness with the court on this. It's helpful.
Thank you. Our point, however,
I understand.
however,
I'm not conceding your point.
Well,
That's that but we're just discussing how this works in the practical world out with all the parties.
correct. Our fundamental point here is that there was no subject matter defect. So if there was no subject matter defect, the court can set everything else aside. Everything else aside. If there was no subject matter defect, then plaintiffs had 30 days to file a motion for remand, and they missed that.
Only if you're correct that the deemed filed is the actual file date under California law. If you're wrong about that, then they were timely.
I would respectfully disagree.
Okay.
I would respectfully, because 1447 doesn't talk about that issue. 1447 sets a hard deadline. It's 30 days from the date of the notice of removal. And that's what happened in the Martinez
Well, right,
case.
but my point is, if the first notice of removal is a legal nullity, then we're back to the supplemental notice of removal, and then they would be timely. And that's what I'm saying is if the first notice of removal, which hinges on California law as to whether it's a legal nullity, if that is a legal nullity, then we don't have a timeliness issue. So really the main issue we have to decide is back to my initial question, which is what do we do with these two statutes in California law?
So, unfortunately, I don't have a case in either direction that I can point Your Honor to.
That's really that's the question we're being asked to decide is what these two statutes mean for purposes of filing.
That I agree with.
And if it then we got a cascade of questions because that doesn't mean you win, but that's a prerequisite for you winning.
That it is. Again, I don't know that I would characterize it as a nullity. We obviously disagree with the district court on that. Obviously, if this court considers it a nullity, then I think Your Honor is correct that we're back to the same point. If it's a nullity, then we probably do have to go with the supplemental notice of removal. That's not what the district court did. The district court didn't look at the supplemental notice of removal.
It didn't, although it did say that it was a legal nullity.
Yes, Your Honor, it did say that. And again, that's why the Martinez case, even though it goes against us, ultimately, it's not a case that is decided in the same way we would like it to be decided. That case did recognize that the 30 days for the motion to remand is triggered from the date of the notice of removal, irrespective of the deemed filed official filing state court statutory issue. In that case, the plaintiff filed the notice of removal within 30 days. The district court nonetheless remanded because of the form defendant rule, and that case is not subject to appeal because that's straight up form defendant, timely motion for remand. That doesn't trigger a lively issue, which is how we believe we're properly in front of this court.
Right. Let me find out.
I do have
Go
a question.
ahead.
If something you said earlier, and my memory may be faulty, but in 1446B, when the 30 days to remove a case begins to run, the statute says it's 30 days after the receipt by the defendant through service or otherwise. Did you say that there was a case that clarified that it has to be service? Because the statute says service or otherwise, so when your courthouse news service pulls a complaint for you and you have it, then it seems your 30 days would start to run then, even if you weren't served.
I think that's correct, Your Honor, and I truncated it, and I should have said service or otherwise. Typically, I think we look at service because whether a party has courthouse news service or not, we know when service happened. But I think Your Honor is correct, and in this case, we would have been, and if we're looking for an incongruous result, we would be on the clock for removal because we already had notice of the otherwise. We already had the complaint.
Is law interpreting that or otherwise? Because, I mean, there's a whole bunch of ways in which otherwise could be satisfied. It was a high-profile case, and you posted it on the Internet, or Fox News reports it, and, then what? You have to have litigation over, whether you're watching the news reports or...
The only case law that I'm aware of interpreting the or otherwise is a case that, and I don't remember the name of the case, but it's not our fact pattern, but it's a case where the plaintiff sent a courtesy copy, a pre-filing courtesy copy to the defendant and said, hey, I'm about to file this. That, the court said, that doesn't trigger anything.
Because it hadn't been filed.
It hadn't been anything. It was just a courtesy.
The statute doesn't talk about notice, so seeing a report on the news is not sufficient. The statute says, by receipt. 30 days after receipt. Correct. By service or otherwise. So the reason I was focusing on this was because earlier Judge Nelson asked you a question about triggering the deadline to file the notice of removal. So this could actually play against defendants as well, but that also raises a specter of some satellite litigation over whether the defendants actually received it. Did they pull it? Did they have it? How do you prove that? And did their 30 days expire because they didn't file the notice of removal after they went and pulled a copy before it was served? So, I mean, those are all the problems of pre-court filing, a pre-court filing rule or official filing. Official filing, yes, but I think what happens here, Your Honor, is because Courthouse News, Dexcom received the complaint through Courthouse News Service. That's in the briefing. Courthouse News Service could not have obtained a copy of the complaint if it hadn't been of course, if
initiated.
It hasn't been electronically submitted.
Correct.
But if we have to interpret these statutes, if we said it could only be when it's filed, we'd be writing out the word or otherwise, right?
Well, the or otherwise comes from the service statute, not from the filing statute. So I don't think you would be writing out those words. But what would happen is the concept of deemed filed, that at least in this context would be written out of the statute. That would create.
If we went against you.
Correct.
Okay, are our questions answered? All right, I'll give you 2 minutes for rebuttal.
Thank you, Your
Thank
Honor.
you. Good morning.
Good morning, Your Honors. My name is Minku. I represent the appellees in this case.
So I think you sort of know where we obviously are familiar with all the facts and everything here. I think so you don't have to, you can jump right into wherever you want to jump.
Your Honor, the Dexcom is making what I consider to be a head start argument. They want the head start, and as the name suggests, it is fundamentally unfair. And as this court asked the questions.
Okay, but I don't think we can deal with the fundamentally unfairness. I think we've got to read these statutes because, I mean, as you've heard us discussing, it's fundamentally unfair across the board. Like, there's a whole bunch of implications based on how we interpret this. So it could be unfair to defendants. No, I understand you're saying, or excuse me, it could be unfair to plaintiffs in the future case. Right now, in your case, you're saying it's unfair to you, but we've just got to set the law down, and it seems to me that it boils down to this interpretation of California law. What can you give us to tell? I mean, why don't we read deemed filed as filed?
Well, you should read that as deemed filed, but that applies to a general rule. Like there's an insurance policy with the specific conditions that you got to read in conjunction with it. That's how this statute should be read. That's a general statute that says anything that's normally submitted to the court will be deemed filed on the date that it's submitted. Now, those concern 99.9% of the pleadings that does not require the clerk to take any action, including processing, checking for filing fees, and making sure that it conforms to the local rules, and then entering it into the docket. Motions, any other pleadings would be deemed filed because it does not take any action on the clerk's part to accept or reject.
So what's your best case for that? You don't have one exactly like this.
Well, it's in the statute. The reason that Your Honors point out that there aren't any cases in California is because the California statutes are very clear. Dexcom is arguing only a portion of the statute that talks about general pleadings being accepted and deemed filed on the date. There are more specific provisions, as the court acknowledged. For example, the very definition of electronic filing in 1010.6A1D states that the definition of electronic filing is the act of filing itself and does not encompass the clerk reviewing, processing, and entering it into the docket, which are all necessary steps for that to be officially filed.
See, there's no doubt in my mind, with the absence of case law here, I think as Judge Nelson and Judge Beatty, we're not trying to give either of you advantage. We're trying to interpret the statutes. There's no doubt in my mind if, let's say, they had waited over 30 days from when the electronic filing happened, that you wouldn't be screaming the other way. Both of you are here to represent your clients, and you're gonna do it to the best. So it's really important that if we come up with a rule, that it's a rule that everyone understands, and it doesn't, and by its nature goes based on the statute, not on what you want, not on what they want.
Sure.
Because I don't doubt for a second that if the roles were reversed, you'd be screaming, you'd be filing against them if you thought you had 31 days from whether the filing or the electronic, that you'd say, oh, you're too late.
Well, Your Honor, this case stemmed from clear-cut case law and of clear-cut federal and state law with regard to removal. The federal removal statute clearly says a defendant that's been served with initial pleading, which the California court determines to be the complaint that's filed, meaning officially filed and stamped and entered into the docket.
See, you just did a little jujitsu there because why does it mean officially filed? Why doesn't it mean deemed filed?
Because the California Statute 350 states that initial pleading is an action is commenced when the complaint is filed. And that's what's stated.
Right, but that's my point. It says filed. It doesn't say officially filed. It doesn't say deemed filed. It says filed. So we've got to determine whether deemed filed is enough to satisfy that statute or whether, I mean, I understand why you're advocating for officially filed.
You're saying this is easy. He's acknowledged that it's hard. We're going to tell you it's hard. So don't tell us it's so easy, because it's not.
Your Honor, it's deemed filed on the date for things other than a complaint and a cross-complaint. And that's why California statute...
Okay, what does that mean? What is it deemed filed? Because the other thing that is interesting about the statute is in A1D, it says, does not include the processing, the electronic filing does not include the processing and review of the document and its entry into the court's records. But I think if you were to pull up the California docket, there would be an entry to say, here's the electronic filing date. Am I wrong about that?
My understanding, Your Honor, is that it will be deemed, there'll be some record of receipt of it, but it wouldn't be deemed filed.
No, that's not true. It would be deemed filed. The statute seems to be very clear about that. We don't know what deemed filed means, but the electronic filing is enough to deem it filed. It's not enough to officially file it.
For purposes of the complaint, Your Honor, the official filing is that's required. Because if you imagine a scenario...
But why? You keep saying that as if that's a given. Could be. Why? What's the difference under California law between deemed filed and officially filed?
For an action to be able to move forward, officially filed is the requisite per statute of 350.
Because your point would be maybe there's a deficiency in it's deemed filed, but maybe there's a deficiency. And then if the deficiency isn't cured, then the action never moves forward.
Absolutely, Your Honor. Just like the California statute carves out for complaints and cross-complaints dealing with statute of limitations issue, the fact that there is a filing does not mean that the case is able to go forward. There has to be certain requirements that are met for the action to move forward, so the complaints are treated differently than other pleadings under deemed file rule. So for purposes of the complaint, it's as if...
Where do you get that? Oh, you get that from these statutes.
Yes.
That's why, because these statutes don't apply to they only apply to the complaint. Is that right? Well, no, that's not true.
They apply to all the electronic
they apply to any
filings.
document.
Correct.
So I don't understand why you're saying it's a different rule for a complaint than any other document.
Well, because the complaint...
Because it seems like every other document we'd be counting based on deemed filed.
Right. And that's the reason why that there's a provision specifically dealing with complaints.
What's that provision?
It is the 1010-6 E4E, which talks about the complaints and cross complaints. If the complaint or the cross complaint does not meet all the requirements for it to be moving as a filed action, the clerk obviously must reject it, and then there is a safe harbor that's created for the plaintiff to be able to submit based on the rejection, and then the statute is told during that period. And that is the only pleading that deals with the discretion for acceptance that's required, which is part of the steps that must be reached in order to get it to be filed. Other pleadings are not dealing with this kind of discretionary act on the part of the clerk. So the general provision, while it is applicable also to the complaint, there is a separate provision that narrowly further limits how the complaints are accepted in order for the cases to move forward. As the court previously pointed out, it is fundamentally unfair to have this complaint deemed filed on the 23rd of November when the plaintiff was not able to serve the defendant. There was no possible way for the plaintiff to be able to stop the SNAP removal by Dexcom because we wouldn't be able to get the summons under any situation. We could try to call the clerk. They would say, you know what? We can't issue the summons until the complaint has been verified, processed, make sure it meets all the requirements for filing to be accepted, and docketed and given a case number. And that's what occurred here. So even though the November 23rd submission date is the submission, for all we know, for purposes of our complaints, it could have been rejected. And if the plaintiff never decided to move forward, refile those cases, there would be no case. So the real question, the simple question in this case is, on the date that Dexcom removed this case on November 28th, 2022, would the case been able to move forward in federal court? The answer is no. There was no pending case either in federal or state court for all intents and purposes. So to remove a nullity, there is nothing to remove. If under case law and under California statute, a complaint has not been docketed, was not given a case number, summons had not been issued, there can't be a scenario where that case is known to exist and be allowed to move forward. So looking just at the time...
I mean, I understand your point, but known to exist, that doesn't seem to be true because they knew that it existed before it existed.
Well, Your Honor, this court...
And it really did, because one day later there was a file stamp. So it wasn't... But I guess, counsel, your friend on the other side here said that probably there is nothing on SNAP removal in the Ninth Circuit, and he said as much as he might like us to decide it probably this isn't the vehicle for that. What's your position on that?
I would turn the court's attention to the U.S. Supreme Court that was decided in 1999, Murphy Brothers case versus Machete Pipe Stringing case. That was the case that determined and analyzed through service or otherwise component of the removal statute. Justice Ginsburg, delivering the majority opinion, analyzed 4 situations where that removal statute and the time period...
Rather than leaving me in suspense, is this a proper vehicle for a SNAP removal decision in the Ninth Circuit?
It's for the removal statute, Your Honor. So it didn't have to do with the SNAP removal per se. It was dealing with actually the removal under diversity. So yes, in the sense, yes. And it actually...
So can you answer my question?
Yes.
Rather than just, I think very linearly here. Is this particular case, do we have to decide in the Ninth Circuit whether SNAP removal should be allowed?
No, Your Honor.
Because
the removal statute clearly states, 1446 states, a defendant. And that term is significant. It is designating a party litigant who has been served with process to be able to be held into this in a court of law to answer for itself.
Well, you're telling me that's why we shouldn't allow SNAP removal. I'm asking you whether we should decide that issue.
No, Your Honor. I was just referring to the status of Dexcom as a defendant. When the party becomes a defendant for purposes of to be able to use the removal statute, and as the Murphy Court determined, through service otherwise, there is a clear scenario, and the scenario that applies to our case is that when a summons and the complaint was served together, as we have in this case, the clerk starts to run from the receipt of that service of the summons and complaint. The case law is very clear, directly on point, and that says it starts from the date that the defendant becomes a defendant through service, and the otherwise portion really refers to a situation where the plaintiff has requested with a copy of a filed complaint for acknowledgement of service or waiver of service. It does not mean having a courtesy copy, getting an uncertified copy of the complaint that they obtained through some other means.
Well, first of all, I don't think you've actually answered Judge Callahan's question. So, but you've now raised a bunch of questions in my mind because it seems like the other or otherwise could include. I don't think that's been legally determined. It could include receiving the complaint through a service.
Yes, but it's got to be a filed complaint, stamp filed complaint. And that's what we have here.
The statute says that?
That's, yes.
The statute says it has
Well-
to be filed. Okay, I'll go look at it.
It's and this court has determined a similar issue and cautioned against removing based on unfiled complaints. That was the Casola and BMW Financial
Okay,
Services
so
case.
can you go back to Judge Callahan's question, because she's been very patient, but you haven't answered her question in the last 5 minutes. Should we even decide that issue? You're telling us how we should decide it, but you understand the question. Do we have jurisdiction to decide? Do we have appellate jurisdiction to even decide the SNAP removal issue?
No, Your Honor.
Oh, well, that was easy.
So, I apologize. No, Your Honor. The very limited issue is whether the district court had discretion to declare that it did not have subject matter jurisdiction. There was no filed case.
Said that. I know you said it emphatically throughout your brief, but I didn't see that anywhere in the district court's order, and I read it several times. The district court didn't say that it lacked subject matter jurisdiction. Can you point me to the page where you think that language is, and I'll look at it again?
Yes, Your Honor. The page 4 of the district court's opinion, a proper removal requires a complaint to have first been filed.
But
And
that doesn't say anything about the court's subject matter jurisdiction. The court had subject matter jurisdiction if, at the minimum, from December 8th, when the supplemental notice of removal was filed.
At that point, Your Honor, through operations of the service and the motion, which was raised at that time, the court dealt with the timeliness of plaintiff's motion to remand. At that point, at the time that the notice of removal was filed by Dexcom, there was no case. So the court talks about how...
But Judge Beatty's point, I think, is that on the 8th, when the supplemental notice of removal was filed, any subject matter deficiency would have been cured. So now so we're not talking about a subject matter. We're not talking about the district court subject matter jurisdiction. I think at this point we're talking about our appellate jurisdiction.
At that point, Your Honor, when the federal court presumably, arguably gained subject matter jurisdiction with the supplemental filing, at that point, the plaintiff has raised...
You say presumably, arguably. I don't see that as... I don't see how can you contest that?
Your Honor, I'm saying that by supplemental being of legal effect and assuming that that is valid way to cure the defect, then at that point, plaintiff had already raised the forum defendant rule and had objected to the removal and asked for the remand. At that point, defendant was properly served and joined.
That's the problem, is it doesn't really matter. I mean, we're sort of dancing around because it doesn't really matter. Subject matter jurisdiction might have attached, but there was no SNAP removal issue at that point because they had been properly served before the supplemental notice. What would have been more interesting is if a supplemental notice of removal had been filed before they were served, but that didn't happen here.
Correct, Your Honor. That's right.
So I thought, my understanding of your briefing was that the reason you were so fixated on saying the district court didn't have subject matter jurisdiction was under 1447C, which sets the timing. And so the district court could have remanded at any time if it didn't have subject matter jurisdiction, as opposed to within 30 days. So you could waive your your forum defendant defense. But it isn't valid. The district court just simply doesn't say that and never concluded it didn't have subject matter jurisdiction. So I think your briefing almost entirely went off down a rabbit hole on that particular issue and didn't address what we're talking about today. I guess that's not really a question, but it's problematic. So I guess you could try to tell me one more time where you think it is in that order that the district court says it doesn't have subject matter jurisdiction.
Your Honor, the discussion is that it was a discussion of a nullity being removed. There's nothing to remove if there's no pending state action. And from that, perhaps I'm stating to you...
Remind me of senators. Rather than answer the question, you start off on some other area. Can you answer Judge Beatty's question? Where in the district court order does it say that about subject matter, that the district court didn't have subject matter jurisdiction? Where does it say that?
Your Honor, it doesn't say directly exactly that it doesn't have subject matter jurisdiction. It talks about the fact that removal at the time that it occurred, there was no pending action, there was nothing to remove. and ergo, there is no federal jurisdiction.
Well,
But then there was shortly thereafter when a supplemental notice of removal was filed, even if you're correct. So the district court never said, we're remanding because we don't have subject matter jurisdiction. The district court said this case is being remanded because of the form defendant rule, which is entirely different. That's a non-jurisdictional waivable defense.
Your Honor, but this court shouldn't get that far. The initial removal at the time that it was filed was a nullity. There was no pending action under federal or state law. It only could have moved forward once the supplemental notice was filed. At that point, there was an objection to remand the case. And the court decided that the remand was proper in this case. And even if this court disagrees with some rationale or the reasoning that the district court used to get there, a decision right for any reason must be affirmed in this court. And that has been the rule of the law in this country. So even though that district court may have reached certain aspects of the SNAP removal that the judge may not need to, or even if the judge did and was wrong about it, the point is that the district court was correct, that there was no pending action at the time that this case and the removal was filed under state law, that there was no filed initial complaint that could have been served to move the case forward. So without a pending legal action recognized at the time of the removal, there is no federal district court jurisdiction. And that's why that was one of the reasons that was remanded, and that's why this court were asking.
That's not why it was remanded. I mean, it's clearly not why it was remanded. You seem to be missing the point that your argument is the clock didn't start to run for us to file a motion to remand until December 8th. That's your argument. Not that the district court didn't have subject matter jurisdiction, but that the clock didn't run for you to file a motion to remand until the supplemental notice of removal was filed because the earlier notice was invalid.
Correct.
It's a simple argument.
Yes.
And then your argument is the district court then had authority and was within its jurisdiction and to decide whether the form defendant rule applied. And that we don't have subject matter jurisdiction to consider that if the district court was acting within its authority.
She doesn't even get paid for that.
Thank you.
But
Yes, that is the argument.
We're not trying to trick you. Sometimes we're actually lobbing you softballs, right? You don't have to stick to something that we've told you is not correct. So there you
All
go.
right.
I won't charge you for that
Questions?
advice.
Well, thank you.
All right, we've taken you significantly over, as we did with the appellant, and so we'll conclude your time on that, and 2 minutes for rebuttal.
Thank you. I really just have a couple of points, and obviously answer any questions that may remain. The question here is whether Your Honor just identified that the forum defendant rule is non-jurisdictional and it's waivable. And that ties into what plaintiff's counsel said, that there's no possible way to stop the SNAP removal. That's not true. Plaintiff had 30 days to file their notice of removal, their motion to remand. Had they done so, which is exactly what happened in Martinez, this wouldn't be an issue. The district court, as the district court did in other cases, would have remanded the cases. We know that.
But isn't the argument for a SNAP removal that if we moved for removal before we've been served, then we don't fall within the language of the statute, that the form defendant statute? So her point is if you can file a motion to remove before they serve you, they could never circumvent, they could never have the form defendant rule applied, assuming the Ninth Circuit were to say, yes, this is legitimate and follow the other circuits that have done that.
If the Ninth Circuit were to do that, which again, I think the one thing we agree on is that that's not a proper issue before this court. Right now, we know that the district court does not, this district court in particular does not agree with SNAP removals. This district court has issued dozens of opinions remanding cases. This particular judge has issued dozens of cases.
But we can actually trump that district court if we wanted to, but you're saying it's not here.
I sure would like you to. I sure would like you to, but I don't think I can, I really don't think I can ask you to. But I think what this raises is a really important point under 1447. 1447 talks about defects other than subject matter jurisdiction. A premature removal, even if that's what it was, is a defect other than on subject matter jurisdiction.
Assuming it's not a nullity. It could be more than just a defect. It could just simply not exist.
It could. I assume that's.
I'm not sure. Look. We're probably belaboring this too much, but I'm not sure I agree, at least on its face, that that's not a subject matter jurisdiction question for similar reasons that what Judge Beatty was just saying. I mean, if it's a legal nullity, I'm not sure why that isn't a subject matter.
I think it's not a subject matter jurisdiction question because generally, I'm not aware of any subject matter jurisdiction question that can actually be cured. I mean, if there's no diversity, there's no diversity. If there's no federal question, there's no federal question.
But
Because if you don't properly plead amount in controversy, and then you file a supplemental and properly plead amount in controversy, I think then you do cure a subject matter.
Respectfully, I think the subject matter jurisdiction was there all along. It just wasn't.
It wasn't properly presented.
It wasn't properly exactly.
So
Yeah,
if there were a subject matter jurisdiction issue because the premature notice of removal was invalid, it would be cured when you filed your supplemental notice. So the district court did not lack subject matter jurisdiction.
I don't think the district court lacked subject matter jurisdiction at all. And
but even if it did, it didn't by the time it issued its order.
Correct.
So we're not grappling with subject matter jurisdiction.
I don't think we are. And if we're not grappling with subject matter jurisdiction, 1447C says that the motion for remand was late by a day.
All right, I think we've taken you over the over.
Okay.
So thank you both for your argument in this matter. Very interesting
Honors.
case, and you will hear from us when we're able to notify you. How's that? When we can file an opinion. All right, the next matter on calendar for argument